COVID-19 legal concerns. What's top of mind for hoteliers and, of course, the entire hospitality industry? Joining us today is Jennifer Miller Brooks on the right in the center. Yeah, she's Jennifer is one of the founding partners of Hamilton Miller Birthisel. They're in the Miami area, but they have an international practice in defending businesses and insurance companies, and her practice focuses on a lot of industries, retail, restaurants, product manufacturers, distributors, and more. And we've had Jennifer speak at several of our conferences, and we always enjoy having her back. But as you can see, she's also been honored many times, certainly AV rated, Martindale-Hubbell, Woman of the Year by the National Association of Professional Women, and named as the top lawyer by the South Florida Legal Guide, and as a super lawyer in law and politics. So she has some very interesting stories to share. Joining her on her right, my left, is Schuyler Smith, also a partner in Hamilton Miller in the Miami office. And she concentrates her practice on the defense side, complex personal injury, premises liability, toxic tort. In other words, complex being the operative word. And she represents a lot of the major hotel and resort chains throughout the country, and I believe internationally as well. Yeah. Virgin Islands, right? Yeah, lucky you, right? Yeah, which will be great. And joining them today is Mr. Jason Bloom, also a partner in Hamilton Miller. Jason focuses his practice primarily representing insurers throughout the U.S., a lot on the coverage side. And we also were going to have Anderson Kill on this here today, but unfortunately they had to not show, but that would have been very interesting because they represent the policyholders. So I would have loved to have listened to that conversation. But ladies and gentlemen, please welcome Jennifer, Schuyler, as well as, and thank you, as well as Jason, and thank you all for joining us and stepping up early.
Thank you.
Please welcome. Thank you.
Thank you so much, Stephen, for that great introduction, and Taylor and your entire staff for having us here today. I got to tell you that the topics have been on point and amazing. All the presentations have been so informative, and it's been a pleasure to be here today with this group. I haven't traveled in probably maybe once in the last 2 years. So I was telling Liv over there from Rimkus how I had to check my bag last night, so it took me forever to get through the airport because I packed too many things because I'm kind of out of practice, not used to traveling these days. But we're here to talk about a topic which is obviously top of mind for all. It's a taboo topic today, I'm sure, because a lot of us don't want to talk about it anymore. We're tired of hearing about COVID, tired of talking about COVID, tired of thinking about COVID, tired of wearing masks and the like. And but we're going to touch on some of the ways that we as an industry can avoid and mitigate exposure to claims related to COVID. As you know, most of those claims are now focused on class action lawsuits. And my firm started out as an admiralty and maritime law firm. So we started out, and I'm actually board certified as an admiralty attorney before I went on to do other things. And so we represent all the major cruise lines. So we have a wealth of knowledge of these claims related back to the norovirus and other issues related to cruise line defense. And as you know, they're all just a floating hotel anyway, which is how I got into hotel and retail industries as well. But we're here to impart some of our knowledge based on that experience and also what's going on now with this pandemic. So, you know, just a overcap of where we are, and then we'll get into the law, and then Schuyler will talk about some specific ways we can mitigate risks as it relates to some of our vendors and customers. Jason will focus on how we can mitigate risks related to our employees, and then talk about some of his background and experience on handling contract issues and coverage issues as it relates to this area as well. So obviously we're in the process now of full reopenings. There are a lot of places within the state that are fully reopened, meaning no masks, no protocols in place whatsoever. And then there are other places like Florida that are kind of half the state is open and half the state is not. So, you know, obviously vaccines are readily available. And so we're in kind of a different climate, if you will, versus obviously when we started this whole process 2 years ago. There have been a multitude of guidelines that have been promulgated along the way We're going to talk about how that creates a moving target as it relates to determining what the standard of care is or what's going to be applied to you as hotel owners and retailers as it relates to some of these lawsuits. And then, of course, how the lawsuits thus far are shaping up. And so let's just get back right into it. In terms of the law that applies, the standard of care, easy enough, is going to be standard of reasonable care under the circumstances. The under the circumstances portion is what is going to be problematic. And why? And that's because obviously when we started the pandemic, we knew little about this disease, how it spread. We knew some things, but not everything. Obviously, we anticipated through a scientific standpoint that there would be some swells and ebbs and flows of this disease. And the goal was to get to herd immunity so that we wouldn't have to deal with some of these ebbs and flows. But ultimately, the standard that's going to be applied to these cases all depends on what portion of the pandemic we're in at the time that the exposure was made or the ailment ensued. And so when you're looking at that time frame, we've got to be very specific as to when was the exposure. Was it in 2020? Was it in 2021? Was it in 2022? Because the standard, as I mentioned, is a sort of moving target to figure out what is reasonable under the circumstances. Obviously, less stringent standards in the beginning when this just started, and our anticipation of what was to come was less rigorous to now, when obviously we know how the disease is spread, and we're generally on the same page as to how to prevent the spread. So what we're looking at now in terms of reasonableness under the circumstances, we're looking at the sources of reasonableness. And so that includes the Center for Disease Control's number one, I'd say, gold standard to look to when you're looking at sources. And from those guidelines now, we as an industry, the hotel industry in particular, through the Association of Hotels, has actually promulgated their own industry standards. Retailers have done the same. And so when we look at the federal guidelines, the state guidelines, the city ordinances, all of those things are going to be sources of what is reasonable under the circumstances as we look at these cases. And what we're looking at now is over 3,000 claims. Most of the cases that we're seeing have been brought as class action lawsuits. Most of the cases that we're seeing have been brought, so we separate them between employee claims and third-party claims, if you will. And the third-party claims are generally based on exposures, especially as it relates to these large class action lawsuits. So I've been exposed, I was in a hotel or a cruise line or a retail setting that, I was around thousands of people, and I fear that I may contract COVID-19. So a lot of the early cases were basically pled in that fashion. And the courts summarily have just been, no, sorry, that's not enough. They've either punted the case or stayed the cases to see, if anything actually came of them in terms of the clientele, but in terms of the plaintiffs that had filed lawsuits, or they've summarily dismissed the cases. So that's good news for the industry. But the individual claims where folks were hospitalized, where they either died or suffered severe complications, those cases are more difficult to defend. So the early cases have all been challenged either based on lack of causation. That was the number one defense. How can you prove that you contracted COVID-19 at my particular restaurant or at my particular hotel or at my particular cruise line? And so that has been the challenge. And then they've been challenged based on a lack of proof of actual damages as well. So Schuyler's going to talk a little bit more about how these federal guidelines, the CDC guidelines, how the state laws, and how the standard of reasonable care is actually applied in these cases on a specific matter.
All right. So by a show of hands, how many people are sick of wearing masks? It's not everyone, so that's good. So like Jen said, the crux of what lawsuits and claims stemming from exposure to COVID will center on is really what did the premises owner, whoever you may be, what did they do in order to take reasonable steps to protect their guests and employees from injuries. And so we have a list here, and obviously this list is not exhaustive as far as things that can be implemented in the businesses to put people on notice. They're already on notice by virtue of the fact that we've been living this reality for 2 years, but to consistently put out information such that people that intend to bring claims, which they invariably will, can't point to the fact that the owner of the establishment did provide them with information and guidance. And so I always say that if someone gets sick, they're going to sue. It doesn't matter if there's no basis for the lawsuit, but it's going to happen. So we know that there's a good likelihood that we may face claims and lawsuits, individualized or in a class action fashion, with respect to injuries that are allegedly brought on from exposure to COVID, whether or not there's a basis to do so. So some of the things that we've all seen, I'm sure, and probably have in our various premises are things like temperature checks. When you walk into a lot of hotels, you have the little thing at the front that you have to step into, and you get your temperature checked to determine whether or not you're elevated and could be sick. And we would not otherwise know that unless that machine was there, telling us that there's something that we may want to dig a little deeper in with this particular guest. So you have those types of products that are installed in the premises to provide the owner with knowledge of what's going on with a person. In addition, we have medical questionnaires, and this, I think, comes up a lot more in, for instance, a spa within a hotel. So you're not necessarily going to ask people to check all the things about whether they're exposed or they have a fever or if they've had COVID in the past week or whatever it may be when someone's just checking into your hotel. But with respect to, for instance, the spas, where you're having a lot more direct contact between employees and guests, that's a tool that a lot of entities have been using and using it successfully. We also have the standard social distancing. We have the markers on the floor that at least reminds people, because I think we all want to forget about COVID at this point, but it at least reminds you that, hey, you may want to social distance and give the person in front of you or behind you some space. Masks, that's a reality unless you live in Florida, where we are anti-masks. I think a lot of us at this point, we're tired of it. And then you have a lot of touchless options that a lot of hotels I've seen have implemented, and some started before the pandemic. So you can get your mobile key. There's no need to go to the front desk and interact with people. You can just make your way to your room and be within the confines of your own space. In addition, with respect to the restaurants that we may have, issues with, a lot of restaurants are now, to the extent they can, using disposable equipment, such as plastic knives and forks or things of that nature. You also have the instances where you're trying to prevent congregations, and so a lot of buffets and self-serve type restaurants have been trying to implement new policies where you either have someone that's serving you and it's still the buffet line, but you don't have access to all the food and things that are out, which again goes towards preventing contamination and leads to, I think, safety. And so I think also what's important to bear in mind is that what's reasonable as far as what the premises owner needs to do to keep their guests and employees safe, it depends on where we are in a given situation. So like Jen alluded to, what would have been reasonable back in April or May of 2020 may not be the same today. I think where we're at now, there's been so much information and guidance put out there by all the medical professionals that what we can do to ensure that we put our company in the best position is to put the information out there. People know it's there, but you need to remind them such that when a claim comes down the road, you can point to the fact that I had signs for this, I had markers for that, and you, guest, also have to take a level of responsibility for your own safety. And that brings me to warnings. In any negligence claim or claim that tort claim that could arise from a COVID exposure, the question of the duty to warn comes up. So what duty and what obligation did the premises owner have to provide the guest or employee with information for them to take necessary precautions? And so the answer to the question of whether or not there is a duty to warn is generally yes. And that, I think the warnings that we're talking about here is a reminder that COVID still exists, despite the fact that we've been fatigued by it. So there may be signs that can be put up that, make clear that these are the symptoms to watch for. If you have a fever, you should probably go seek medical attention. Here's where you can go. And putting out information that reminds people that if they believe they're sick or they've come in contact with persons that may have been exposed, please go do something about it or let us know so that we can also protect the other people that may come in contact with you. And that goes to guidance. Jennifer spoke about the different organizations that put out information for us to obviously compound upon if we would like, but also as at least a base of what is required. So the different organizations obviously have put out various guidances, which I would say are the bare minimum for operators and owners like our audience here. But I think it's important for the owners to have their own sort of plan, have your own policy and procedure and plan that really sets forth what your company is going to do, either to meet the CDC or other guidances or to far exceed that. And we know that when claims come down the line, your corporate rep is sitting there. One of the questions that plaintiffs' lawyers often like to ask is, tell me about your policies. Okay, you had a policy that all your employees that served food needed to wear their masks and wash their hands and use sanitizer with this amount of alcohol. Were all these things being done? Because Mr. Witness over here indicated that the chef did not have a mask and was anti-mask and didn't wear the mask. So you need to make sure that you have prevention measures that are in place and that they're followed. And so there ought to be checklists or some sort of avenue that you can ensure that your employees are doing the things that the company has promulgated and put in effect. That also goes to training. Training is obviously a big thing that all premises owners at this point have had to take a step back to ensure that their employees are trained on COVID, what to do, what not to do, and how to respond to things that will invariably come up as they do their duties. Now, I spoke on this just now, but basically the duty to warn is to extend to the guests that are on your property. And there are various things in addition to the signs and things that I just mentioned that can protect you from liability. And one of those things are liability waivers. Waivers are tricky because they vary from state to state, whether or not they can be enforced and what the specific and particular language of the waivers need to include to ensure that guests and persons are reasonably apprised of what they're giving up. But that's definitely something to consider, particularly in instances where it's some sort of voluntary activity that's being performed. So it could be an excursion that a hotel offers on their property, and so you're going to go in a bus with people, or you're going to be on a boat with people, or you're going to be in a scenario where you're interacting with folks that are outside of your party. You can probably have a waiver there that indicates that any and all liability which pertains to exposure is limited and excluded based on your assumption of the risk, essentially. Okay. With respect to the duty owed to protect the spread to customers that may come onto your property, basically, we all will have folks that come onto the property and they may become positive. And so that goes for both employees and guests. But at the point that you are provided with information that a guest or someone has tested positive for COVID-19, what obligations, if any, do you have? And you do have an obligation to identify that person. You have an obligation to ensure that that person is isolated such that exposure will not be spread among others. Have them quarantine, whether it's on property or off property. Disinfect and clean and ensure that you have, at least initially, a third party or a vendor that can come in and properly clean and disinfect so people believe that they're safe even though there's been an exposure. And you should then offer testing to the persons that may or may not have come in contact with the infected person. And so one of the issues that comes up with respect to identifying persons that have said, hey, I have COVID and I was, exposed to other people is what information do you have to provide to others? Do you have to tell all the guests in your hotel that there's been a person that's been exposed? And I don't think there's a hard and fast as to whether or not that's yes or no. It really does depend on the circumstances. So for instance, we could be at this conference today and we find out on Monday that 10 people tested positive. Does the hotel have an obligation to, let the other members of the group know? Does hospitality law have an obligation to do so? It just depends. And because you want to be conscious of people's medical and privacy rights, but you also want to give people the opportunity to be fully apprised of what's going on and be able to take steps to ensure that they make the best decisions that they can. How do you reduce the risk? It's everything that we've touched on a little bit, but ensure that the applicable CDC guidelines and other guidelines are followed. Definitely be in touch with your state and local departments that can help you in terms of dealing with breakouts, or also providing resources for testing, vaccines, providing information to folks, and just making sure that you have a plan in place and procedures in place to attempt to do what you can reasonably do. The law, I believe, is consistent that we as hotel, restaurant, or other owners are not the insurers of our guests' safety, but our obligation really is to do what's reasonable, and that's all we can do. So I'm going to turn it over, I believe, to Jason to talk a little bit about the employee side and what we can do on that front.
And I just want to kind of follow on what these ladies were saying. Some of you were sitting here online hearing all these things that we're telling you that you still need to do. And certainly part of the analysis we're providing today is for prospective risk. Where are you going to be exposed in the future? But a lot of what we're saying also applies retrospectively. If these claims are going to be coming down the road, what are some of the things that these plaintiffs and claimants and attorneys are going to bring to your attention? They're going to say, why didn't you follow the CDC guidelines? Why didn't you follow the AHLA proposed written guidelines? And certainly what you're going to hear us say over and over again is that the standard is going to be reasonableness under the circumstances. So prospectively, rates are going down, hospitalizations are going down, injuries are going down. But if your property, if your restaurant, if your hotel publishes on its website, as we heard about a little bit earlier today, the steps that you're taking to prevent members of the public from getting sick, and somebody comes in there relying on on those representations and you're not following whatever the current CDC guidelines is? What are members in your competitive set doing? What steps are they taking? Are they putting shields up? Are they still monitoring for temperature? So this type of analysis needs to be done in real time. There's a prospective consideration of what could happen down the road, but there's also retrospective consideration for what's happened over the last couple of years. So keep that in mind. You want to be in a scenario, God forbid, we had Omicron, what's next after that? Lambda, Omicron. I mean, the next iteration might be more serious. And then if you've now relaxed your guidelines and your practices, you've thrown out your protective masks, you threw out your thermometers, your staff has no idea what to do, and another wave hits, right? So these are things to keep in mind and to be prepared for in the future. And one of the things that you're constantly going to be facing is the health and safety and the welfare of your employees. You as a retail operation, as a hotelier, as a restaurant, have an obligation, an affirmative obligation to protect your employees. And so you need to take certain measures to make sure that those employees are kept safe. You know, if there are at-risk employees, elderly employees, disabled employees who might not been able to get a vaccine, for example, you know, if there is an outbreak and it's still happening in our law firm, we're still getting emails. People are getting sick with COVID. You have an obligation to provide testing, to provide these employees with the ability to take time off of work, and that obligation exists today. Again, reasonable under the circumstances. CDC guidelines, OSHA guidelines. OSHA is an excellent resource. They publish online still today what industry should be doing in light of COVID. So while popular sentiment might be prevailing and, you know, feels like we're free and moved on from COVID, you know, make sure you're compliant. Monitor your regulations. Next slide. So just as an example, the CDC has published what the obligations are, what the best practices of an employer are for its employees in COVID, and they talk about issuing testing to its employees, and they talk about different scenarios when testing should be provided. Testing employees who provide symptoms, testing employees who have been exposed to the virus. Testing all employees at each shift or at regular intervals is a recommendation by the CDC. I don't know how many operations are currently have regular intervals of COVID testing, but there it appears on the CDC website. And sure enough, if somebody gets very ill and they said, well, if you guys had been monitoring the situation, this wouldn't have happened. You better believe that's going to be an argument that you're going to be confronted with in a lawsuit. Testing employees before they return to work. And even the fifth one I found very interesting, for some owners and property operators that have extensive operations, maybe you have a big resort, for example, that proactively finding certain areas where hotspots might develop, maybe where there's a lot of face-to-face contact, a spa, beach, or poolside where there's a lot of contact, testing at hotspots. So just be aware that these things are going on. I do, before we jump to the next slide, I know we're running short of time, want to bring to your attention just a couple of the issues we've seen in employer-employee litigation in the hospitality industry. The first thing that everybody should be aware of is, especially as counsels, for those of you who are general or in-house counsels for these operations, is the statute of limitations. A lot of organizations will say, hey, I have 1 year, I have 18 months from a certain moment to close their books on certain issues, but you need to be aware that COVID in 20 different states and different smaller municipalities and courts have extended certain statute of limitations periods. In New York, it was something like 280 days of time. And it still remains to be whether they have an additional 280 days or whether it was just 280 days from an expiration, but these are issues you need to be aware of. Are you paying your employees who are out, who had to go get tested when they took time off of work? Are you clocking them out and making them go stand in line? Or did you in the past in whole or in individual context? Because that is a litigation that's currently pending. Do you guys have hazard pay policies for your operations? Do you pay employees who are engaged in harder levels or labor intensive amounts of work? And if so, have you applied that throughout COVID? Did you obtain PPP funding on the promise to your employees that there were going to be certain benefits if they were to just stick it out and work through the labor shortages. These are all issues active in litigation throughout the country right now. And again, prospective is one thing, but also we have 2 years of potential claims that still may be brought. By far and away, the largest category of claims that have arisen out of COVID in the employer-employee context are actually based on discrimination. Now, for example, are elderly employees more difficult to employ when there's staffing shortages or longer hours? Did you let older staff go because of these issues? That was found to be a discriminatory practice. There was a hospital group in Massachusetts who had only minorities going to clean the COVID-infected rooms. Courts didn't like that. Certainly, these type of issues and in implementation of your operations, you need to keep in mind certain regulations. And like I said, discrimination suits have by and far been the largest group of them. And just at the end here, I know I was introduced for my experience in insurance coverage, and I do have a lot of that. But I also handle a lot of contractual disputes in mixed-use properties with brand licensing agreements and hotel management agreements. And our firm and myself individually was in the trenches the last 18 months when COVID, became an issue, and then how it rippled and affected throughout the industry. I saw my practice have to deal with different types of issues arising from closures. And sure, 18 months, restructurings and financing concerns, certainly closing operations have been tough. But my advice from my experience over the last couple of years dealing with some of the issues and fallout here is that it's an opportunity for each and every one of the entities that are operating, whether you're a hotel, whether you're a restaurant, whether you're a mixed use, whether you're an owner, whether you're a manager, take time to take a look and examine your contracts. Who are the responsible parties? Who are the entities that are operating on your properties? Do you have a staffing service that you're using to bring in labor? Are you outsourcing your security? Are you outsourcing your certain services being provided to your hotel or to your restaurant? And if so, who is responsible for getting that insurance? Who is supposed to be a named or primary and additional insured on these policies? And are you making sure, if you are the entity that's supposed to be receiving insurance, that you are named? Or vice versa, are you naming those entities? I have a property in Miami who each and every single unit owner in a mixed-use property has an obligation to name the property owner and the hotel manager as an insured on that policy. When's the last time the property manager or the general counsel went through and checked and verified that each of those owners had fulfilled that obligation? Well, the answer is not soon enough, not recently enough. And of course, a lawsuit comes out, and the owner says, "Oh, I sold that interest from my personal name to my corporate entity. My corporate entity owns that unit now, and the insurance coverage is now an issue for a substantial claim." Take the opportunity now, after the fallout, after the dust settles, after things calm down, look at your contracts, look at your insuring obligations. Certainly, in my practice, a lot of account receivable and collection actions, both defending and prosecuting. Force majeure was raised today, it was discussed briefly today, and whether it applies. Well, the question is, were you prevented or was it made impossible for you to perform your obligations, or did that vendor obligee, could they not perform because of COVID, or because they lost when they didn't feel like it? These are issues that are still going to play themselves out. And as everybody in this room knows right now, over the last 3 or 4 months, we've seen price instability across the board. Now's the opportunity to kind of lock in some of your contracts. If you have leverage in your negotiating positions, take the opportunity now to address what's likely going to be future uncertainty over the coming months and potentially years. And so in summary, for all of that, thank you for giving us the opportunity to speak today. Reasonable under the circumstances. Be reasonable. And what is be reasonable? It doesn't mean, well, I saw it on TV and so that's what I think should be, or my uncle told me I don't have to worry about this. Check your guidelines. Check the publications. Check your industry publications. Talk to your colleagues. See what's going on in the competitive set. Make sure you have these policies implemented on your properties. And if they are implemented, make sure you're following them. And if you're going to change them, make sure that you're changing them not because you feel like it's time, but because the guidelines have changed. And if you ever have any issues, then you can call one of the three of us, and we'll be happy to help. And with that, take any questions you guys might have.
Yeah, that was great. Thank you. I wish we could have compiled all this 2019, right? Before 2020. That would have been awesome, right? Yeah, speaking of prospective, yeah, that was terrific. Jason, I have a quick question, just, and that is that, there's a lot of business interruption claims.
Sure.
Based on COVID. And we had a lot of sad hotel and restaurant groups out there. And I'm not saying you're the reason for that sadness.
I might be.
But I'm just curious, did that kind of philosophy that it has to be a physical damage, right? Did that stick in the cases that you've been in? You able to get out of most of those claims via summary judgment? And do you see policies changing in the future, or we're just going to stay the same?
So that's an excellent question. And anytime I mention that I have any experience with insurance, that's the first question I get. Business interruption. And the bad news for the policyholders is that the universal application of the case law across the country is that COVID is not an actual physical damage to a property, which is a necessary condition to trigger your first party business interruption insurance. There is currently, as last count, one judge in Missouri. So if any of the St. Louis operators here, one holdout judge in Missouri who is allowing the case, not that he ruled in favor of the business for the interruption, but has not dismissed the case summarily at the opening bravos of the lawsuit. But aside from that, there's been essentially universal acceptance of this idea that on standard business interruption policy and coverages and insurance policy, COVID did not apply. Now, that said, speak to your insurance professionals. A bad experience is an opportunity for a better outcome the next time around. This is an open market, and if you want to procure certain coverages, it may cost, but now is the time to have that conversation.
Yeah, thanks. That's very helpful. Sad, but helpful.
Sad but true.
I want to. This next question, I want to connect some dots, Andrea, if you don't mind, if I caught you mid pretzel or. But I just want to confirm that there's a general consensus that employers in the United States can insist that employees get vaccinated. Is that generally speaking?
Generally, there's a handful of states. Tennessee, Montana, several who have. Florida, who have.
I think we can all figure out those states. Yeah, okay.
Montana surprises us all the time, that have put either anti-discrimination laws or anti-vax passport laws in place.
Okay, so now Jennifer, I'm passing the ball to you. But so given that, but I'm not in one of those states, but I'm kind of anti-vax as an employer. But the CDC says you need to be vaxxed. I'm assuming from a reasonable care perspective, vaccines are the way to go, and I'm letting my political persuasion interfere with my business sense. Is that fair?
Yeah, that's fair. That's fair. Obviously from CDC perspective, it's vaccination all the way. It's booster. It's the max of whatever we can get to try to stem this disease. But in terms of, yes, the exposure that we potentially face in certain states where they say, you cannot force employees to get vaccinated, then what are you going to do with them? You're going to fire them if they don't get vaccinated? So
can't get employees anyway, right? So you're not going to fire them.
And if you're not going to vax, then test, right?
Then
test. Your obligation on testing.
And every day they come in, you test.
Yeah.
Yeah. So there's got to be, so that's pretty much the middle of the road position. It's suggesting vaccination, and then if you don't want to get vaccinated, then test. Mm-hmm.
Okay, interesting. And Schuyler, I've got a question for you because I think I slept through my international civil procedure class, but I am curious because you practice a lot in the Virgin Islands, right? And that is right. So what is the jurisdiction, or is it a whole different body of law there than it is in the U.S.?
Not completely different,
Okay.
but the general principles are the same. There are some nuances though with the Virgin Islands. Most, if there are any companies here that practice there, they probably hate it. It's very local friendly. It's very for the people. But the general negligence principles, duties, obligations are the same. Things take a very long time to get to resolution, unfortunately. So that's a struggle that US companies typically have, in that they don't understand why things are taking so long, even federal court, but that's just the nature of the system.
In terms of high verdicts, it's second only to Texas.
To South Texas.
South
Yeah,
Texas,
yeah.
yeah, South
Yeah,
Texas.
Brownsville more than likely.
And I think the most famous plaintiff's attorney there is from Texas. Yeah.
Oh, is that right?
Lee Roan, yeah.
Oh, what's the
She's
name?
Her name is Lee Roan,
Okay, great.
ROHN, and she's the Morgan and Morgan nemesis of the bar there. So.
Isn't that interesting? Well, that's good.
She's originally from here.
We export those. Okay, that's good. Well, just a real quick funny story. I had to make an appearance down in Key West. This was many moons ago, and so I went down in my suit and tie, thinking, I'm going into court in Key West, and everybody, including the judge, was in a Hawaiian shirt, and I lost before I even walked in. Before I even walked in the door. Sadly, that's a true story.
You would have the same thing in the Virgin
In the Virgin Islands?
Yeah.
Okay, I know who to call now for my fashion advice. Guys, thank you very much. That was just great
Thank you for
information.
having
Really appreciate it.